Hi, I'm Steve Richardson of Richardson Law Offices, and this is the November 2017 episode of Lunch with a Lawyer. And today we're going to talk about how New Jersey lawsuits work. Now, as I was mentioning in the earlier comments on the Facebook Live event, this is to give everybody an understanding of the process, whether you're bringing suit or whether you're being sued. It's also always good to know what the facts are, what the realities are, how the system works, so that you have realistic expectations, so that you know what your rights are, so you know what can or can't happen. So we're going to talk about that today, and hopefully you'll find this information very useful. But because I'm a lawyer, there are a couple of disclaimers and things I have to sort of put on the record first before we go any further. First of all, this show, the Lunch with a Lawyer, is really for informational purposes. It's to educate. It's not for the purposes of giving legal advice. In this instance, I'm talking about how New Jersey lawsuits work, but that each case, each lawsuit is different, and there could be all sorts of variations on this or fact-specific situations. So you should just take it with a grain of salt and understand you should see a lawyer or talk to a lawyer about this. It's also not a how-to session, okay? It isn't designed to tell you how to bring a lawsuit or how to defend yourself against one. It's just, as I said, informational. And of course, although it needs to be said, I think common sense, it doesn't create an attorney-client relationship. So if you watch this video, you're not my client, okay? But if you're thinking about bringing a lawsuit here in New Jersey, or you're being sued here in New Jersey, it's very important to talk to a lawyer about it so that you know the process end to end. Okay, let's get started. And I'm first going to talk about how a lawsuit starts. And it starts with the filing of two essential documents, the summons and the complaint. Now, here in New Jersey, a complaint is basically a statement of facts and allegations laid forth in numbered paragraphs, and usually grouped together in what are called counts. Count 1, count 2, count 3. And these counts are often used to separate out different legal theories, and then each factual statement under each legal theory for each count. So it may be a complex commercial litigation case, and you may be arguing breach of contract, negligence, fraudulent inducement into the contract, all sorts of different legal theories that get broken down. But essentially, the complaint is the lawsuit itself. Okay, and it has the allegations, and it's saying, accusing the defendants or of some sort of civil wrongdoing. This is not criminal, this is civil wrongdoing. So that's what's laid out in the complaint itself. Now, the summons is a document that is issued as somewhat of an instruction sheet that goes to a court officer as far as where to serve the complaint on you, which I'll get into service in a minute. It also lays out instructions for you on, if you're being served with it, on what you need to do to respond to the lawsuit. It has some important information, and if you've been served with a lawsuit, it's very important to read the summons carefully and to follow those instructions to protect your rights. But that's what a summons is. And the lawsuit together is referred to as the summons and complaint. Now, in New Jersey, we have other documents that are often attached to that. You'll see a case, depending on the court you're in, a case information statement or a tract designation sheet. There are other things that might be attached to it when you get served with it. But those are the two main things, the summons and the complaint. So that's the lawsuit itself. The complaint gets filed. Sometimes, depending on the New Jersey court you're in, the summons gets filed separately, and then everything goes out to the court officer for service. So That's how a lawsuit gets started. Now, the next step is that that lawsuit has to be sent to or served upon each defendant. There could be one defendant, there could be several of them, and each one of them has to be served. Now, this is ordinarily done in vast majority of cases in one of two ways. One is personal service. A court officer walks up, hands it to you. Sometimes you'll see that on TV. Somebody will come up and say, "Are you so-and-so?" And they'll say yes, and they'll say, "You've been served," and hand them some documents. That could be a lawsuit, it could be a subpoena, it could be any number of things, but that's personal service. Now, personal service in New Jersey, if it's against an individual, then it has to be served either on the person or on a member of that person's household over the age of 14. So your teenage daughter could accept service basically for you because she's considered old enough. She's over the age of 14. And that's considered good enough service. Now, if your neighbor's over visiting and you're not home or some such thing, and they accept that they're not a member of your household, that was handed to the wrong person. So that's the rule. It's either served personally on you or served on a member of your household over the age of 14. If that doesn't happen, then there's a serious issue as to whether there was good service. I've had a case, a client was served at an old residence. He hadn't lived there in years, but it was the last address that the plaintiff had, the person bringing the lawsuit, and they served that suit on this person that did live there. And so that wasn't considered good service. That's the first way, personal service. The second way to do it is it can be done by certified and regular mail. So it goes out both by certified mail and regular mail. And if you get that, that's the thing, if you see something that looks official in an envelope and it's certified mail, you get a card, open it, take a look at it, okay? If you're worried, hey, what am I being served with, or what's this certified mail, and you're fearful, and you don't accept the service, you don't sign the green receipt card, but the regular mail goes through, that's still considered good service. Sometimes people will ask me, well, I got this in the mail, but I never accepted the letter. I never signed the green card. Well, it doesn't matter. So a lot of times, people aren't home when the mailman delivers a piece of certified mail. They're not there to sign. So they end up having to go to the post office to sign for it to get it, and people don't bother. It's a lot of trouble. So you may not get the certified mail, but if the regular mail goes through and is not returned by the post office, is undeliverable, or they're not here anymore, or they were, but the forwarding order expired, or some such thing. If the regular mail goes through, even if the certified mail was unclaimed, it's still good service, okay? So that's service by certified and regular mail. Now, and the next step is you've been served with this complaint, or you've had the service complaint. Then the next step is the defendant or defendants each has a period of time in which they can file a written document disputing the allegations in the complaint. It's called an answer, and it's an official court document that addresses each of the claims in the complaint. Now, it's in essence, the summons is going to tell you how much time you have to file that answer. It's usually 35 days from the date you receive the summons complaint. And if it's served by certified and regular mail, there's a presumptive period of time of 3 business days after it was sent out in mail by the plaintiff or the plaintiff's lawyer. So you have 35 days to file an answer. So you have to file an answer that basically responds to each of the allegations in the complaint, each numbered paragraph in each of the counts. If there are multiple defendants, not all the counts may apply to you, but you really do need to respond and respond within that period of time. And so you prepare this document, it gets filed with the court, and there's usually a filing fee to file that answer, and you at the same time have to serve or send a copy of the answer on the plaintiff's attorney, the person that brought the lawsuit. Now, you also have that at that point the ability to bring your own lawsuit against the plaintiff. It's called a counterclaim. They're claiming something against you, and you're countering and suing the plaintiff. So you can have people suing each other. There's also something called a third-party complaint, in which you're filing an answer and saying, no, I'm not responsible, this other person is, and I'm bringing them in. It's called a third-party action. A little bit more involved than what we're going to get into in today's talk, but that answer can serve different purposes beyond just your denial or response to the allegations made in the complaint. I just wanted to mention that. So you have that period of time. Now, let's say you filed your answer, and now we have a disputed lawsuit. What happens next? Or you brought this complaint against somebody, and they filed an answer, and they're disputing what happens. Well, then the next step is what's called discovery. And unlike a lot of what you see in courtroom dramas, there's very little surprise. There's very little that the attorneys don't already know when they go to trial. And in fact, you can object to certain things being introduced into evidence or testified to if that wasn't provided in advance through the discovery process. It's called unfair surprise. You can't sandbag people with this stuff. All right, so there's a discovery period where the parties look to get all the information they can about the complaint. So the defendant's going to say, well, no, wait a minute, you're accusing me of all of this. What's your proof? What do you have? What witnesses do you have? What are they going to say? What documents do you have? Let me see those documents. Complete disclosure and back and forth in the discovery process. And there are different tools that can be used for that. One tool is called interrogatories. And they are basically a set of written questions. And you have a certain amount of time to bring suit. A certain amount of time to answer those written questions. So you go through and you have to answer each one. They may involve attaching documents or that you use as part of your answer, but it's basically a set of written questions. And you have a certain period of time in which to answer them. And if you don't answer them, there can be consequences. The second are called requests to produce documents. Just like answers to written questions, they have the ability to, or you have the ability to ask this question of people: what documents do you have? Give me all the correspondence, a copy of the contract, pictures, video, anything, any physical evidence or things like that would count as a document. And these days, with so much that is electronic, there's electronic discovery, all sorts of computerized records and things like that, and it can get very involved. The third are called requests to admit. And what they do is it's a series of statements, individual statements. And unlike statements made in a lawsuit and claim you did this or this happened, you can't just deny it and say, prove it. If it's true, you have to admit it. And the purpose of the request to admit is to sort of weed through the issues and find out, look, what's disputed and what isn't. Let's not waste a lot of time over what the parties agree happened as far as facts, and drill down to what's really disputed. So you have a certain obligation in responding to these requests to admit, and responding to them within the period of time as either admitted or denied. Or you may not know enough. You say, I have no idea whether this is true or not, and that's an acceptable answer. But you must respond truthfully. If it's true, admit it. If it's disputed, deny it. If you have no idea whether it's true or not, then indicate that. If you don't, as I said, not responding to discovery can have consequences. If you don't, then they have to be answered within 30 days, they can be deemed admitted. All right? So you don't answer them, you blow it off, you ignore it, then those are all admitted. And later, if it goes to trial or what's called summary judgment motions, I'll get to in a moment, hey, it's all admitted. It's no longer in dispute. So very powerful tool if you're bringing the lawsuit or if you're defending yourself, these requests to admit, because it can really cut through a lot of things and drill down to what the real dispute is. So requests to admit. There are also things called depositions, whereas in interrogatories, there's a set of written questions. The depositions, you sit down in a room, and you usually have some attorney's conference room, and you sit down and there's a court reporter there taking down everything that's said. You're put under oath, and it's basically like you were testifying at a trial, because you're under oath. You know, if you lie, it's false swearing, it's perjury, but the only difference is there's no judge there. Okay, but everything else is pretty much the same. You are making statements under oath and answering questions. It's a lot more open-ended and less formal in the question and answer process, but that's what depositions are. So these are the ways in which the parties, the litigants, get information and find out the proofs about the case and thoroughly examine everything before it ever goes to trial. At some point, the discovery process will be over, and you'll be ready to proceed towards trial. And so what will happen sometimes is there's something called dispositive motions. After discovery is over, one party say, hey, you don't have enough really to bring a suit. You don't even have foundation for it. This is total nonsense. And they make a motion to dismiss. Or they make a motion for what's called motion for summary judgment. And what that means is, look, Your Honor, I know we're finished discovery and we're going to be scheduled for trial, but there really is no dispute as to facts. Why have a trial and bring people in and testify as to all these facts when the facts really aren't disputed? These are the undisputed facts. All you have to do is review those facts and apply the law. And we argue the law. This is why this person owes me money. This is why they're responsible for my injury. These are the undisputed facts. Apply the law that we know it as we know it to be to these undisputed facts and rule. Okay? Obviates the need for a trial under those circumstances. Now, sometimes you go through the whole enchilada, the whole case. Sometimes it's a motion for partial summary judgment. There may be some of those counts that are undisputed, and you need the judge to rule on them, and others are disputed. So even if you do go to trial, that trial can be shortened because you may have summary judgment. Those certain counts or certain allegations have already been addressed by the court, already been ruled one way or the other. And you're either arguing to say, yes, they are liable under the undisputed facts, or as a defendant, defending the case, you may say, no, there is no liability for this under the undisputed facts, and you should rule in my favor, in the defendant's favor. So that's a summary judgment motion. Now, let's talk about what happens if you don't file an answer. Let's back up a little bit. You've been served, or the other side has been served. They don't file an answer. What happens next? Well, a default is entered by the court, either automatically or upon request of the plaintiff, depending on what court you're in. And that default prevents even a late answer from being filed. The door's closed. That's it. And then, depending upon the type of case, proofs are then presented for the entry of judgment. For either if it's a suit for money damages, for that, for if it's for an injunction ordering you to do or not do something, then that can be done by default judgment. Entering default can be difficult, though, sometimes if you're dealing with someone in the military. There's the Soldiers and Sailors Relief Act, and the requirements in New Jersey are that if you've got someone deployed and they're overseas and they're not home, they may have been served. Remember I said somebody over the age of 14 that's a member of your household. Maybe your daughter, as I said, accepted service, but you're in Iraq or Afghanistan or some other place deployed and you can't take action. Then default cannot be entered. You have to wait till that person comes back and has the ability to file an answer. Fair is fair. You get your day in court. So that that can be a wrinkle. And when you request a judgment be entered, you have to establish that this person is not in the military. There's certain databases you can check and proofs you can get, but you have to take that step to protect someone in the military from not getting their day in court because they're off somewhere. So let's say judgment is entered. Hey Norm, how you doing? Glad you could join us. Thanks for joining in. If you have any questions, let me know. And you kind of missed part of it. Hopefully you go back and watch it either on Facebook or it's going to be on YouTube in a few days. So what happens after judgment's entered? Let's say that it's a judgment for money damages. Okay, and now that person has a judgment against you, or you have a judgment against that person. Well, that's nice, and it says they owe the money, but how do you get the money? Okay, that's often the practical aspect of these lawsuits is how do you turn those judgments into money? Well, once the judgment's entered, you can issue what's called a writ of execution, and that writ can be used in different ways. You go levy on your bank account, okay? Freeze those funds. Now, if you've had your funds frozen, then you should go to njbanklevysurvivalkit.com. That'll give you all sorts of information on how to assert your rights in a bank levy. And if you're bringing a bank levy, you have to be aware that there are certain monies that can't be levied upon, Social Security benefits, veterans benefits, things like that, certain pension benefits. Also, in general, the depositor, the debtor or defendant is allowed to keep up to $1,000 of personal property, whether that's money in the bank or some other piece of personal property like a car. But they can exempt, and if they apply to your bank levy, protect up to $1,000. So if you've levied on less than that, well, it goes back to the defendant. So they can levy on your bank account. They can also garnish your wages. Now, you can only have one garnishment at a time. So if there's someone in front of you and you're trying to collect on a judgment, you have to wait until the other one's finished, and people get in line. But it can take quite a bite out of if you're on the receiving end of one of these. Take quite a bite out of your paycheck. Usually amounts, although there's certain calculations involved that I won't get into here, but it usually amounts to 10% of your gross pay during that pay period. So that's another way they can collect. Those are the two big ways. They can levy on other personal property like a car, but that's usually not the biggest target because it's not a liquid asset. It's not wages. It's not money in the bank. So they usually don't go through that first. If let's say they don't know where you bank or where you work, okay, or you don't know, you've gotten a judgment against somebody, but where do they work? Where do they bank? Where's the money? How do I find out? Well, you find out through something called an information subpoena. And what that is basically it's a standard form court document, and it's served upon the person against whom you have the judgment, and to say, look, where do you work? Where do you bank? What are your assets? Who else do you owe? Things like that, standard stuff. Basically, tell me where your stuff is so I can try and take it. All right, it's galling to get one of these if you're on the receiving end of an information subpoena that you have to help them collect a judgment against you, but you must respond within 14 days of receipt of that information subpoena, or you could be held in contempt of court by a judge. And usually that contempt threat is used as leverage to basically get you to answer the information subpoena. So that's how they can, if you have a judgment against somebody, you can find out this information, and if you're on the receiving end, what you got to do if you receive one. So that's, in a nutshell, how a lawsuit works here in New Jersey. I hope it was informative, and also hopefully if you're bringing a lawsuit, that you understand how it works. And some couple of takeaways are Just because you sue someone and get a judgment doesn't mean you're ever going to collect it. Okay, that's that's just the first major battle. You can go to trial and still win, but unless there's an insurance company there or a bond or somebody else willing with money ready to pay the claim, you may have to jump through some more hoops to try and collect. So that's a practical aspect of it. And another thing to bear in mind, if you're involved in disputed litigation, it's going to take time. All right, this is something that's very frustrating to people. Most major lawsuits in New Jersey, the discovery, by the time you serve everybody and have discovery, it's at least a year. Okay, just the discovery process before you even get to the motions, like motions for summary judgment, or even start to get onto the trial track. And of course, the dockets in New Jersey can be a bit crowded, and it can take a while the older cases are sifted through before you get your turn. So just be aware, if you're bringing a lawsuit and it's disputed and they file an answer, it can take some time, and you may not be able to collect. If you're being pursued by somebody, and if you're on the receiving end, and this often happens with collection lawsuits, if you are if they haven't sued yet, if it's a credit card company, a collection agency, and they tell you, well, you better pay by the end of the week, or we're going to attach your wages, or you can go to jail for this, or some other lie. It's not only not true, but it's violating your rights, and that under the Fair Debt Collection Practices Act, which is a whole other thing that we can talk about some other time, maybe another topic for another day. But if a collection agency is something saying, you can go to jail, no, nobody goes. There's no debtor's prison. Okay, you don't go to jail because you didn't pay a debt. And they're not going to be levying on your bank account by the end of the week or garnishing your wages by the end of the week because it hasn't even gone to a lawyer yet, let alone this whole process I just explained. So again, knowing how the system works helps you understand your rights and be realistic about the process itself. So that's it for Lunch with a Lawyer. Hope you found this beneficial, and I'll see you next month at lunchtime for a new topic. See you then.